there are certain limitations that have come about due to the emergence of both the digital platforms along with the AI models. Because competition law, the traditional tests that have existed jurisprudentially over the last 100 plus years have been focused a lot on pricing and price-based tests. That is one area where there is a bit of a struggle to apply those tools into the current free services model that most of these platforms operate on. Right. So that is one area where there is a challenge.
Hello and welcome to Macro Deco. We have anti-competition laws to ensure fairness in the market and provide a level playing field for all the companies. How effective are these laws? And with the emergence of digital platforms, how adequate are they in ensuring fairness? Let's talk to Aniket Ghosh, partner, competition law and data privacy at Stubb and Kasiva. Welcome to the show, Aniket.
It's a pleasure to be part of this.
So what are the common forms of anti-competitive conduct that you are seeing in different sectors in India?
So I would say broadly, there are three buckets of conduct that we see in the Indian markets. So the first, of course, is the most common one, which is the cartels and the bid rigging cases, which is the most common form of cases that you see, particularly in the public procurement space. There's a lot of these tenders which get manipulated, or you have 2-3 players who are related parties and public procurement also on that front. Particularly the CCI has taken a lot of proactive measures to educate and sensitize officials in the government also as to what are the common signs that would suggest there's a cartel, and how they should refer those kind of cases to the CCI. Roughly around 35 cases in the last 5 years has been entirely on cartels, and this is plaguing many industries. The second type of conduct which we have seen in India has been the abuse of dominance. There is a slight misconception that a lot of people have that, being big itself is bad. But actually, the problem is not being big, but just the fact that if you're undertaking any kind of unfair practices just because you're large and you can just get away with it. And we see that happening in different sectors again. So again, it's a very cross-sector problem. And the final one, of course, is the vertical restraints. Now, what that essentially means is when, as an enterprise that has a substantial market power, whether not necessarily dominant, you are imposing unfair terms and conditions on your suppliers or downstream purchasers. So we see a lot of these deep discounting cases, for example, exclusivity tie-ups. Currently, the maximum that action from the CCI on this third category, which is the vertical restraints issue, we are seeing a maximum of that in the context of these internet businesses like the e-commerce platforms, Amazon, the quick commerce platforms, the investigations against Zomato. So all of these digital markets particularly have been impacted by CCI proceedings in the context of these vertical restraint issues. So to sum up, essentially, cartels are the biggest menace. They have the abuse of dominance cases from time to time. You have the Indigo example, the Asian Paints example, there are plenty that we are seeing action on. And then you have the final category, which is the vertical restraints cases.
So as we just mentioned that Competition Commission of India have been taking some steps, but how effective been in the past to curb this kind of anti-competitive practices?
Right. The CCI has evolved into a very sophisticated regulator. So had a fair balance in terms of both engaging on investigations and ordering them against companies. But at the same time, they have taken into effect business realities sometimes, the overall market conditions, how they are, the fast moving nature of certain markets. Like digital markets, for example, are very fast moving. So, and they're prone to a lot of disruption. So from that perspective, I think the CCI's record has been quite good. From the detection perspective and also in crafting decisions which are both keeping in mind business realities while at the same time ensuring deterrence, I think they've come far from what they were, like, say, in 2012 or 13. But I think the one area where there is some difficulty is the point on the issue of recovery of fines and all of that. So that's one area, because most of the companies always challenge it, and they challenge to the level of the appellate forums and things like that. So the monetary fines realization aspect, I think that's one area where there is a lot more improvement that I think we can probably see.
As you rightly pointed out, the investigations have been going on. We also see a lot of orders coming out of CCI, but we don't see those orders actually culminating into recoveries or penalties. So are the competition laws taking too long to conclude? As the verdicts, as you said, can be challenged in other courts, will this reduce the effectiveness of competition law?
Even the investigations is a time-taking process because unlike most other investigative bodies like, say, the SEBI, the CCI actually has to look at the larger market impact
Right.
of any particular company's conduct,
Yeah.
right? And from that perspective, that is a pretty large exercise because you will need to get inputs from, various stakeholders in the value chain, right? Give a fair picture of what is the actual market harm or market impact of the alleged conduct. It's not only legal evidence, unlike various other laws. Here, you're dealing with economic analysis also.
Right.
You have the new commitments and settlements regime that has been brought about in 2024 when they amended the Competition Act in 2023,
Okay.
wherein companies who wish to offer modifications to their behavior just to close out a case, the option is always available. The appellate mechanism taking time is not such a bad thing also because it does help in correcting and appreciating better evidence. The investigations also taking time is also in a way a good thing because it helps in getting as many views or stakeholders as possible and to have a more holistic argument as opposed to just making certain broad-based allegations, and it helps companies also defend themselves properly. So I think that's not a bad thing in that sense. And there are mechanisms that the law also provides for faster disposals through the settlement and commitment mechanisms that have been brought about in 2023.
Do you think CCI and the appellate tribunal should probably have people who know more about business along with the legal experts?
We have a lot of people from the non-legal side. In fact, the commission has an entire economics division that entirely looks at the market structures and aspects like that. So they are well trained in order to appreciate those kind of evidences. So I think they have had that exposure of understanding business realities while at the same time appreciating what the legal position is. So to that extent, I think the commission is fairly balanced.
So of late, we have been seeing large companies consolidating the markets in different sectors. And you also mentioned earlier that use of dominance is one of the competitive conduct that we usually see. How should we view this kind of consolidation of markets from a competition law perspective? How valid is the argument that having large monopolistic companies in each sector helps the global economy?
Right. So I think that's a very hot topic, I think, overall in our society. I have a slightly differing approach on this because consolidation as such, I don't think is a bad thing because at the end of the day, consolidation enables scale, right? So there are benefits to consolidation. And we also see a lot of cases where certain enterprises who are not doing well, but in acquisition by a better player or a larger player results in ensuring that there is a continuity of the business as well as continuity for a lot of the labor force and the workforce that was previously employed. From a competition law standpoint, like I mentioned at the very beginning, the fact that you might become dominant is not something that the competition law really looks to tackle. There are companies who have achieved scale just because they have developed a valuable product which individuals and corporations really value. Competition law is more focused on any sort of abuse of dominance. They are more focused on any kind of anti-competitive conduct done by such enterprises, but purely from a fact of that there is a consolidation, I don't think that is something to be very alarmed about. In addition to that, the CCI does also have the merger control side, looking into or regulating any kinds of M&A that might cause widespread anti-competitive impact. There are checks and balances that have been provided under the legislation, which the CCI also looks into from time to time.
Even there are concerns regarding companies becoming bigger and monopolistic. If large companies fail, that affects the economy in a large scale.
There are challenges in that regard because there is that concern of too big to fail, which has been there in the US also, where
Yes.
of course the competition law originated, and there were concerns of, particularly in the context of banking finance.
Yes.
That's an area where there's a big concern point. But I think that, frankly, is more of a policy-related question rather than purely a competition legal framework. The competition law framework doesn't really have those tools to be able to navigate it and curtail it because merger control framework that exists is there to sort of look into consolidations that may harm the market.
So, has the emergence of large digital platforms, artificial intelligence, and algorithms exposed limitations of our traditional competition laws? What are the challenges that you are seeing? What are the kind of competition laws that are there? Are they actually adequate to support the startup ecosystem and these kind of dominant digital platforms?
I will definitely agree that there are certain limitations that have come about due to the emergence of both the digital platforms along with the AI models also. Because competition law, the traditional tests that have existed jurisprudentially over the last 100 plus years have been focused a lot on pricing and price based tests. There is a bit of a struggle to apply those tools into the current free services model that most of these platforms operate on. Of course, there is also the question of network effects tipping markets, where there are more users on board and the more users you acquire, the network effects become so large that it is very hard for the competition existing tools to be able to respond. And so it's very fast moving from that point of view.
Right.
And of course, you have the problem, particularly now with AI tools, which is the algorithms resulting in self-preferencing, especially where, so that's another key area, because a lot of the older jurisprudence on self-referencing has focused on dominant companies, not through a particular algorithm. So how do you determine liability in that situation? Those are
Right.
questions which have surfaced in the last 10 years or so, globally as well as in India. I don't think that the response to that is to have a separate law altogether, where you put in certain bunch of obligations or compliances that certain digital platforms need to follow and put that additional burden on them. EU has adopted that approach in terms of policy, where they have a separate digital competition act to tackle only large digital platforms. I think that what you're doing with that is you're penalizing companies for developing a good quality product. The reason why there is so much of network effects and why users get on board a particular product is ultimately comes down to the fact that the offerings are such that users do end up taking it up. And the way the digital markets also work, there is a dynamic competition element which is also there. When it comes to digital markets, what I also feel is that most of these are very fast moving. There is an element of constantly innovating which is required of these companies to keep. And if you don't do that, there will be a new player who will be very easy to, who may come and disrupt the situation. And the entry barriers are not so significant also that it is difficult for somebody to completely grow into the space. The existing framework competition law is there. While there are certain limitations and while there are certain challenges, wherever it has been necessary for the CCI to intervene, it has intervened. Like you see the Amazon investigations, like you see with the investigation against Zomato, the fines that were imposed on Make My Trip, and it has done so on the basis of the existing frameworks only. But in terms of the larger question that whether the CCI is empowered and does it have the means to tackle these kind of issues, I feel it still does, because the existing framework is broad enough to also cater to a digital market scenario as well. There is some criticism, particularly on the fact that these investigations take time, and when it comes to digital markets, quick interventions are important. To enable that also, if you see, the government has also taken steps of introducing, by way of the Competition Amendment Act, of the settlements and commitments mechanism.
The CCI's intervention has been mainly into the already existing framework. Within that framework, it has actually done many things, even with the digital platforms. But when we talk about digital platforms, there is an algorithm. This is a different animal. You actually are not acquainted with this animal. How big it is? How does it work? Even the consumers are not very aware about how algorithms work. And then you have the data which is there with multinational companies, and how much access CCI has to this kind of data, which could be probably sitting in some other country. So that is also another question where, how efficient or effective will be the investigations of CCI, what it needs to be done to actually upgrade itself so that it can meet the new challenges and address the issues with regard to these digital platforms.
Both the CCI along with the investigating arm, that is the DG, the Director General CCI, uh, both of them have all the powers of a civil court under the Act, right? So they have the powers to summon, they have the powers to investigate. The CCI, the DG CCI also has the power to raid and direct raids. So in terms of the data point of view that you mentioned, the CCI does summon for those evidences during the investigating period. Companies are obligated to provide the information, and if they don't provide, the CCI also has powers to compel that production of that information as well. There are mechanisms through fines, there are financial penalties, there are also raiding option, which the CCI is using quite frequently now to enable the DG to gather sufficient evidences in these kind of cases. So in case of any lack of cooperation from that perspective or lack lack of submission of information, there are mechanisms and tools which the CCI does deploy quite regularly on that front. The other aspect that is there when it comes to the data being outside, the problem is not so much about the data being outside. Sensitive concerns, like for example, financial data. There are specific provisions under those legislations, like under the RBI's superintendence. A lot of the payments data itself has to be stored in India, and even a global player like a WhatsApp, when they're using the WhatsApp Pay, they are required to follow that particular guidelines and those particular obligations. So from that point of view, both the CCI has various tools under its powers. One is, of course, fining and raiding companies who do not cooperate. It also has mechanisms of obtaining that data from other regulators. I don't think that currently the CCI doesn't lack teeth. The question is more of how quickly does the investigations ultimately conclude.
So generally, if you look at different sectors, how can we actually balance the competition concerns with industry policy goals? We just mentioned about growth of the economy. So should the laws focus more on consumer welfare or economic goals? What do you think about?
The major objectives of the Competition Act has also been consumer welfare. And if you see, the digital players has actually enabled a lot of consumer welfare from that perspective, because it has enabled the access. Let's take e-commerce, right? A person sitting in a tier 3 city is also now able to access some of the most high end goods, any new novel product that they want to get. So it has enabled a lot of these consumer welfare perspective, and that's something the CCI also keeps in mind when framing its final orders, coming up with what should be the penalty and all those aspects. But at the same time, the act also recognizes efficiency is also another aspect that it does enable, or at least the preamble talks about sustaining competition and freedom of trade, right? And the cleanest test that typically the CCI looks at is whether the conduct as such, are the consumers really worse off, right? So the purpose of an industrial policy is to highlight what are the areas or the sectors that we want to world-class national champions. We want to build that kind of companies, right? So that's what an industrial policy effectively will do. And that's something what the government as a policy decision needs to take up. Whereas a competition policy or a competition law should keep those two separate. Competition law focuses a lot on efficiency, and so it's a bit of a dichotomy from that perspective. So I feel it's best to keep the two things separate, and that's how government should proceed on that point.
Right. So that was Mr. Aniket Ghosh. He was telling us how even CCI, with the traditional framework, has been able to actually tackle the challenges of the digital platforms. And going ahead, it will probably have the team to address all those concerns. But like for any judicial system, it is a problem of speed, time that is consumed to actually deliver justice. That is the problem even with CCI. Thank you for joining me on the show.
Thank you so much, Sangeeta ji.